hear me, Judge? Can you hear me, Corey?
I can hear you now.
Okay. We can't hear you, Judge. I'm still not hearing the court.
Yeah, I can't hear him either. I think we need one of those signs. I think we need one of those signs.
Okay,
There we go.
yeah, the problem is some mornings I log in using the Polycom, and when I do that,
I think we need one of those signs.
right, okay,
There we
okay.
go.
And now I gotta mute my YouTube. Yeah, hold on. The problem is some mornings I log in using the Polycom. So you got to hear that twice. When the Polycom's working, that's how I do microphone and speaker sound, so it all gets picked up here in the courtroom. When it's not working, I have to turn up the sound on the Zoom program that's on my desktop. And I'm frequently going back and forth between the two. Whenever I do, I've got to adjust the volumes, and I never remember until I see people looking at me with blank stares. So, Mr. Kelly, can you hear me now?
Yes, Judge.
Okay. Okay, counsel, how are we doing on this? Are we any closer to getting a resolution?
Well,
I'm sorry, Corey McCord and Steve Rick.
yes, Your Honor. Yes,
Sorry,
I'm
Shannon was asking me who was here.
Steve Rick here on behalf of the petitioners in this matter. Your Honor, we have had some settlement talks further. We had proposed that Mr. Kelly contribute some of his own funds outside of the assets that are apparently available in trust still, but he's not willing to do that at this point. And so we feel like there's still a chance of settlement, but we're not confident of it. We feel like we should just proceed in light of the court's last opinion that was issued on this and move towards a judgment, if necessary, an evidentiary hearing on attorney's fees. I do want to bring one other matter to the court's attention, and I'm sure Mr. McCord may want to address this. Just a little history. Back in March of 2019, the court ordered that the net proceeds of the sale of the real property, which is the primary asset in this, were not to be distributed to any person without further order of the court. Later that month, March of 2019, the house did sell, and $243,000 roughly was provided to Mr. Kelly. We got a statement in August of 2000 saying that the balance in the account was $248,000, so it had gone up a little bit from the 243 proceeds. And then we recently asked for another account balance. As of the end of 2020, the balance had dropped to $241,000, and a statement shows that Mr. Kelly removed $10,150 from the account. I contacted Mr. McCord about that and voiced objection. We feel like, frankly, Mr. Kelly may be in contempt of the court's order for having withdrawn that money, at least to the extent of the proceeds of the sale. And so I want to bring that to the court's attention. My clients, frankly, don't think that Mr. Kelly is a trustworthy party to hold these funds anymore, and they should be held someplace else, perhaps at American Title or something as a neutral party.
Mr. McCord, what happened with the funds that were removed?
Judge, Mr. Rick and I did have those conversations, to be honest, in trying to settle the case. I kind of put that off to the side and I haven't had a chance to talk to Mr. Kelly about it. I'm guessing, and again, a lot of this was prior to my arrival. I'm guessing some of that was used, I'm guessing attorney fees, but I'd have to get some more clear explanation on that. And with reference to the settlement, Mr. Rick is correct. We have had some discussions. I never like to say never on settling things, but I'm not optimistic at this point, Your Honor. But I would have to address that with Mr. Kelly. I'm not sure about the funds. I think it probably attorney fees, that's my guess, but I don't know that.
Yes, gentlemen, it was attorney's fees.
Well, and Your Honor, I don't know if we just want to go back and forth on this, but, you know, in light of the proceedings in this matter, as we reconstructed the total assets, the house was $240,000, but total assets were more like $340,000. And so there should have been plenty of money to pay attorney's fees that were incurred other than out of the proceeds of the sale of this property. I don't know what Mr. Kelly's done with the money. But in any event, at very least, the net proceeds of the sale of the house need to be available for distribution, and they're not currently.
I don't object to a third party, American Title, another attorney, Jennifer Kelly, somebody. I don't object to that. I don't.
Excuse me.
Well,
The
some-
proceeds from the
Go ahead.
sale of the house went directly into the trust account at TD Ameritrade, and only withdrawals were made to pay attorney's fees. There was no 300,000. The proceeds from the house went into the trust account, and the only withdrawal were for attorney's fees.
And I'm sure I could get statements, copies of checks, that kind of thing, if the court or Mr. Rick wants those. I should have addressed this, but trying to settle it, I was more concerned with seeing if we could resolve things and kind of blew that off.
But you can't address the proceeds in isolation. There are various other assets that are involved in this estate, and to say that the proceeds of the sale of the house are the only thing to be distributed, that's just not correct.
So if settlement is not imminent, which it sounds like it's not, then I need to know what remaining issues have to be decided, and will there be the necessity of taking evidence. I frankly, gentlemen, remember bits and pieces of this, but without pulling everything out. It's like one of many, many, many cases that I have. I don't retain those facts generally in my head. I know in the last opinion that I issued that there were issues as to transactions in the estate as opposed to transactions in the trust, where there were allegations of wrongdoing, I guess is a simple way to put it, where funds that were used by Mr. Kelly in violation of his fiduciary responsibilities. Beyond that, I don't remember details. I know those allegations were made, but the estate proceeding was never in front of me until that was raised as a defense by Mr. Kelly's former attorney, that many of the claims, Mr. Rick, that you had brought on behalf of the petitioners related to transactions that preceded the trust. Am I at least remembering that correctly?
Yes, it's complicated, but that's fair. You did allow us to reopen the estate, and so the estate has been reopened. I think it's just a matter of you probably looking back at your last opinion on this matter and reconstructing things. I believe the only asset of the estate was an IRA, and so that's been fully distributed. The other asset, I guess, would be to the extent the estate needs to be augmented by funds that were withdrawn by Mr. Kelly before her death. But I believe the court made a finding on that in terms of what amounts of money were involved, whether it was the estate or the trust, because there were funds withdrawn from the IRA, and the court made at least advisory opinions on that. So I think, we could revisit that. I guess I would encourage you to look back at your opinion, and, we can schedule another matter. At very least, you've indicated in your opinion that you think an evidentiary hearing is necessary for a finding on attorney's fees.
Well, but testimony that I received earlier was received in connection with the trust. Only the trust was involved in the litigation. I guess I can look back, but I don't recall that there was ever, there hadn't been a claim made in the estate. There had been claims made in the trust proceeding that related to things that predated the trust. And I know there were certainly allegations made. Did I make actual findings of fact on those allegations?
Well, I believe you did as to the IRA, Your Honor, which was an estate asset.
So
you did say in the opinion that that ruling was advisory, but you did make some statements as to what you thought were, was probably, to me, it's likely how you'd conclude on the matter. Trying to be fair on.
Well, what I'm getting at is, was there ever any testimony taken on those issues? I mean, I can envision that I would say, well, if Mr. Kelly did this, then indeed that would give rise to a claim for breach of fiduciary duties. But was he ever given the opportunity to present evidence? I didn't do that. Here's what happened. I just don't remember that part.
Okay, well, we could continue talking about it. I remember it well, Your Honor, but I'm not sure how much you want to go into it right now.
No, well, all I'm trying to get into, is it going to be necessary for me to take any more evidence? And I would certainly give Mr. McCord the opportunity to look at my advisory opinion, if that's what it was, and decide whether or not there are any issues that he has not had a full opportunity to present evidence on. If he doesn't think so, if he thinks I've got everything there to make this into an actual ruling as opposed to an advisory ruling, now that the claim is properly at issue, then great, I'm happy to do that. But I don't want to foreclose him from that opportunity if Mr. Kelly was not previously given such an opportunity.
Yes, Your Honor. I'd like an opportunity to go through that opinion in detail. I've been through it. And I believe I have a transcript too that I've been through most of that Mr. Rick was kind enough to send over to me. If I could get a short period of time to go through those things with Mr. Kelly, the transcript, maybe discuss some things with his prior attorney, Mr. Rapley, and sort of report back to you and Mr. Rick. And I think Steve's correct. There was a pretty lengthy opinion. Some of it were findings and some of it was, I guess, advisory in nature, saying, if this is the case, this is where I'm kind of going. So I don't want to continue to spend money for these folks on attorney fees and whatnot, but when we sort of already have a feel for where things are going to go. But if I could get a short period to go through that, that would be great.
And Mr. Rick, you have formally made these claims in the estate proceeding, correct?
Well, probably the answer to that is no, Your Honor. I will say that
does there need to be a complaint and an answer?
I think there is, right, Steve? Didn't you file that right around the time I got involved?
I'm going to have to look back, I guess. We definitely appeared in the estate, but there's been no complaint or answer filed in the estate. There's been no separate civil action filed in the estate. I don't know that there needs to be one. I think that perhaps there's a need for a petition or something like that in the estate to formally bring that before the court. I'd have to look back at the filings on this and confirm that.
It looks like Mr. Rick filed a petition to reopen the estate and objections to the sworn statement to close in August of 20. I filed a response to that in September. There's an order from October. And then since that time, we've been trying to settle it. So I guess it was just a petition to reopen it and object to the sworn statement to close.
But what those specific claims, those specific objections are, haven't been set forth anywhere except in the trust proceeding. Is that correct?
I'm not going to commit to one thing or another, Your Honor. I need to look back at the record on that. You know, the estate's been intertwined in this throughout. Definitely evidence was received regarding the estate. You had copies of statements on the IRA that were submitted into evidence, and those are before the court, and those were strictly estate assets. So there
What they were objected to as being beyond the court's jurisdiction over the trust. And I found those objections to be valid. These aren't trust assets, these are estate assets. And if they're going to be resolved, they need to be resolved in the estate. My recollection is I offered an advisory opinion in the hopes that it would lead to further productive settlement discussions rather than reopening the estate, filing a proper claim and an answer, and litigating anything that's left to be litigated. I envisioned that would be a pretty involved process. So, I mean, the more we talk about it, the more I remember. But I'm sure that was my thinking at the time is, hey, gentlemen, if this is where we're headed, and it looks like we are, there's going to be a lot more money spent on legal fees and a lot more work that needs to be done before we can get to a resolution of all of the claims that have been brought. So having said that, obviously I want to give each of you a chance to look back, figure out what needs to happen in the estate in order to put these matters at issue. To be at issue, there's got to be a claim filed of some kind. I don't know if it's a complaint. I don't know if it can be done simply as objections to final accounting and then disputes to those objections. But it doesn't look like there were specific objections, just we object to the final account. And what I'm looking at in that petition doesn't spell out what the objections are. If that's been done, and I just haven't looked deeply enough in the file, obviously I don't want things to be duplicated, but something needs to be done to bring them to issue.
Very well, Your Honor. I'll take a look at that. And do you want to, in terms of just keeping this matter going here, what will be our next step?
Well, my plan is to give you a schedule. So, Mr. Rick, I'm going to give you 28 days to file any pleadings necessary in the estate proceeding in order to put your specific objections at issue. I'll give Mr. McCord 14 days after that in which to respond to those claims. I don't think we need any kind of discovery. If Mr. McCord, if in looking into these issues, you find there is a need, you can certainly request the court, and I'll consider that based on what the need is. But if there's not, and you've already made your attempt to resolve it, we need to either schedule an evidentiary hearing if there are evidentiary issues remaining as to those things, or if not, if you believe there's enough facts in the record of the trust proceeding that all I need to do is consider your arguments and make a ruling, I'm happy to do that. But I want to make sure that Mr. McCord hasn't been deprived of an opportunity to defend any of those things once those claims are specifically alleged where they need to be alleged, which is in the estate proceeding.
All right. So coming back to the issue we talked about earlier, Your Honor, it sounds like Mr. McCord is not objecting to having those funds held by a neutral third party. And I think that would be the preference of my clients.
Judge, I don't object to it, but I would like to figure out where the 10 grand exactly is and get some canceled checks or something to make sure. I mean, I don't even know, maybe even part of that was used to pay me. I'm not sure.
If there is an order in place that says those funds were to be held in escrow and not dispersed without further order of the court, and something was dispersed without an order of the court, the money that was dispersed needs to be paid back. And the account does indeed need to be put in the hands of a third party so this doesn't happen again.
Okay.
If you can't agree on who that third party is, you can each make a request, bring that to the court's attention, and I'll pick one.
I think we can agree.
I think so.
To make sure nothing more disappears. But absolutely, if funds were taken out in violation of my order, they need to be put back immediately.
I'll look into that shortly, Your Honor.
All right, Your Honor. So I'll file something within 28 days unless we resolve this matter, in which case, if we do, we'll let you know.
All right, and I will set another scheduling conference in 60 days, or a status conference in 60 days, approximately. That's plenty of time for a petition and a response to have been filed to see where we are so that we keep the matter moving.
Very good, Your Honor.
Thank you, Judge.
You're welcome. Have a good day, gentlemen.
Thank you, you too.